If this ongoing battle between parties in this election campaign wasn't controversial enough, lots of people have now sent me this video that's been circulating of this Royal Mail worker allegedly writing racists on the Reform UK leaflets. Let's take a look at this video because there's been a lot of interesting questions followed up from that as well, which I'll hope to get to in this video. But just before we press on, if you wouldn't mind bopping that subscribe button, about 1 million of you watch every month, and I'd like 1 million subscribers. That'd be really nice, but I don't. So please do that. I'll be really grateful. Thank you. So let's take a look at this video, shall we? So this is the video itself. Full credit to the poster on X for doing it. You can clearly see he's got Royal Mail uniform. Now, being the lawyer about it, this isn't absolutely 100% certain that it is a Royal Mail worker, but I'm just being the lawyer, don't shoot the messenger. He's writing something on these leaflets before they come through the door, and then we see an image of the leaflets itself. Now, the leaflets here, you can see, has got racists written across it, written across Reform. Now, it goes without saying, regardless of what your personal views about a particular party, if you are delivering those leaflets, then you shouldn't be writing anything on them at all, much less a word like that, because that would be wrong. I don't think you need a lawyer to tell you that. But there has been a rather interesting question pop up, and that's about the use of the Ring or whatever it is doorbell. I think it's a Ring doorbell or it's a Google Nest doorbell. Both are equally good. I've seen the footage from both. They're both equally good. I've had lots of questions about these in the past. I've done lots of videos about these in the past. I've advised people on these in the past, all to do with data protection, GDPR, the UK retained version thereof, and so on. And so there's a very interesting question that pops up here. If indeed these allegations are true against a Royal Mail worker, they appear to be true from the video, but that's just saying from what I can see. And as I say, it's not a statement of fact because it may not be a Royal Mail worker, being the lawyer about it, but by the by. But if it were, let's say if someone, let's talk about a generic case rather than this particular case. If somebody were caught on a Ring doorbell doing something wrong, and that were then made public and were sent to the police and so on, then there would be no confidence in iniquity is the phrase that we use. So if you record somebody doing something wrong, for example, they are driving a vehicle that might have the company logo splattered on the side, and they are filmed doing something wrong, reported to the police, and they are prosecuted. Or it's a cyclist who runs through a red light and they are filmed going through the red light and that's reported to the police. Or it's put on social media for public interest and things like that. Then, as I say, there is generally no confidence in iniquity, meaning you can't do something wrong, be filmed in the act in a public place, and then claim privacy there afterwards. Now, there's an interesting question as to the landing area for this video, because there's been lots of cases. I've gone into what is a public place, what is not a public place. In another video, I'll try and find it, link it below. But generally, if you Google, you'll find these things, but I will try and find it. There's been lots of cases that have decided what is or is not a public place. And this looks like the open landing access to a block of flats. I don't know whether there's a locked door at the front and so on. I think if there were, the postman will be outside and the post boxes are usually outside of the locked doors to prevent them having to come inside. So I think this is open access inside, but I'm not absolutely certain. But either way, unless it is completely restricted to the public, which in this case evidently it isn't, because if this is a postman, then he's got access, and under the implied right of access to the front door with genuine bona fide business to the front door, he's got access to the front door, therefore it will be a public place for the most part, in my view, and that's without, subject to seeing all the rest of the building and the access and that sort of stuff. So all of those things taken into account, it is entirely probable that this is a public place. Therefore, if someone has been caught doing something wrong in a scenario like this, not commenting directly specifically on this case, you understand, for reasons that Royal Mail are investigating it, and they say a Royal Mail spokesperson, to be fair to them, said they are aware of the video and conducting immediate inquiries. It's our priority to ensure all candidate mail is delivered with the same high level of service. That's what I'd expect from Royal Mail. And that's what they've said. So obviously they will investigate and see what happened. And so If somebody in a scenario like that does something wrong and they are filmed doing it, there is generally nothing wrong with putting that on the internet. If it is in the public interest, they've done something wrong, or indeed if it's sent to the police and so on. So I thought that was an interesting question. There was a question raised in the X thread about whether this was a criminal offence under the Post Office Act of 1953, but that unfortunately is an act that's been repealed, meaning it no longer exists and it's no longer in force. However, that now has been replaced with the Post Office Services Act of 2000, under which Section 83 provides a new offence where a person commits an offence if, without reasonable excuse, they intentionally delay or open a postal packet in the course of its transmission by post, or intentionally opens a mailbag. But as to the damage itself, if someone were to be prosecuted for something a little bit like this, then it's more likely to be prosecuted as criminal damage, because that is damaging property that belongs to another without reasonable excuse or without the owner's consent. And so just to recap the situation with the Ring doorbells in general, the data protection legislation does apply to your property, particularly if your video is capturing area and outside of the curtilage of your own property, which in this video it is. So if I were speaking to the person that owns this video, I would recommend that they speak with the neighbor opposite, because it's clearly facing that door and will be monitoring their comings and goings from that door. And so they either really should have agreement or they should blank it out. So it's going to conceal their identity and ideally conceal when they come and go. That's going to be quite difficult to blank out enough of it to comply with that requirement at the same time as monitoring for the safety and security, but that would be the reasonable excuse if a claim for breach of data protection were made against the owner of such a doorbell. And so, as I say, speaking to somebody is probably the best way of going about it, because if you get somebody's agreement, you can work together for the security of both apartments facing each other using one Ring doorbell. Now, when I say the data protection legislation applies, it doesn't mean you have to go off and register with the ICO, but it does mean you have to comply with the standard data protection principles, which is keeping the data secure, keeping it no longer than is necessary, using it for purposes that it was caught for in the first place. Other parties who are identifiable individuals on the video have a right of access and right of erasure, save for the reasons that you might need to retain it, for example, saying it to the police and things like that. And so really that goes for any standard CCTV around a house. The ICO has some very good guidance on this. There are some heated debates as to whether or not the law applies in that situation, but I can quite clearly tell you that it does. There has already been a fairly prominent case, Fairhurst and Woodard, which I covered in great detail in a previous video, which I'll try and find and link below, where the defendant in that case was found to be in breach of data protection and liable to damages for harassment for the way in which he used that footage. So I'll link that video. You can go and listen to a much fuller explanation of that court case and how these principles applied there. So the law very much does apply, so do take a warning of that. But I hope you found that interesting, and no doubt you've seen it online. I will link it in the description below. Thanks for watching. Make sure you subscribe, and I'll see you next time.